The moment a debt collector calls you, something important has already happened. Before you said a single word, before you even picked up the phone, they may have already broken federal law. Not might have, not possibly. In millions of calls placed by debt collectors across America every single year, federal law violations occur before the conversation even begins. And the people receiving those calls have no idea they are holding legal rights worth hundreds, sometimes thousands of dollars in their hands. Today, I'm going to flip this completely around, because most people think a debt collector call means they are in trouble. They are not. The debt collector calling you is the one who needs to be worried. And after this video, you are going to know exactly why, exactly what your rights are, and exactly what to say the moment that call comes in. Stay with me through this entire video, because the section on how to make debt collectors pay you is the one that changes everything. And it is the section most people never hear because they hang up in panic before anyone tells them the rules actually protect them. My name is Dr. Diane Marshall. I spent over 2 decades working inside the federal legal system. I have watched debt collection companies violate federal law thousands of times, while the people they called had no idea they were entitled to fight back, to be compensated, and, in many cases, to have the debt itself challenged. After this video, that stops. Before we go further, subscribe right now to alert Americans and turn on notifications. Every week, I bring you the information that protects your money, your rights, and your future in plain English. Hit that subscribe button now. Let me start with a law that changes everything. It is called the Fair Debt Collection Practices Act, the FDCPA. It is a federal law that has been on the books since 1977, and it is one of the most powerful consumer protection laws in existence. It governs exactly what debt collectors can and cannot do when attempting to collect a debt. And its violations are so common, so widespread, and so well documented that federal courts handle thousands of FDCPA cases every single year. Here is the part that most Americans never hear. The FDCPA is not just a set of rules that debt collectors are supposed to follow. It is an enforcement mechanism that puts money in your pocket when they break it. When a debt collector violates the FDCPA, you have the right to sue them in federal court. If you win, or if they settle, you can receive up to $1,000 in statutory damages per lawsuit, regardless of whether you suffered any actual financial harm, plus your actual damages if you have any, plus your attorney fees paid by the debt collector. That means finding an attorney to represent you in an FDCPA case costs you nothing out of pocket, because the debt collector pays your legal fees if you win. This is specifically designed to make it easy for ordinary Americans to enforce their own rights without needing to afford an attorney. Now, let me walk through the specific violations that happen most frequently, because knowing these is how you recognize in real time when a debt collector has handed you legal ammunition. Violation number 1, calling before 8 in the morning or after 9 at night. The FDCPA prohibits debt collectors from calling you before 8 in the morning or after 9 at night in your local time zone. This is an absolute rule with no exceptions. A single call at 7:59 in the morning is a federal law violation. A single call at 9:01 at night is a federal law violation. Document the time of every call you receive from a debt collector. Your phone records will show the timestamp. If any call falls outside the 8 to 9 window, you have documented evidence of a federal violation before the conversation even started. Violation number 2, calling your workplace after you tell them to stop. If you tell a debt collector that your employer does not allow personal calls at work, they are prohibited by federal law from calling your workplace again. This prohibition takes effect the moment you communicate it. A single additional call to your workplace after that communication is a federal violation. You do not need to provide this in writing. A verbal statement on a recorded call is sufficient. Violation number 3, using abusive, harassing, or threatening language. The FDCPA prohibits debt collectors from using profane or abusive language, from threatening violence, from making repeated calls with the intent to harass or annoy, and from using obscene language of any kind. This prohibition covers not just extreme cases, but a wide range of aggressive and manipulative communication tactics that many collection agencies use routinely. If a debt collector raises their voice, uses contemptuous or demeaning language, implies threats about consequences they cannot actually impose, or calls repeatedly in a pattern designed to wear you down, each of those behaviors may constitute an FDCPA violation. Violation number 4, making false representations. This is the most commonly violated provision in the entire FDCPA, and it covers an enormous range of deceptive tactics that debt collectors use routinely. A debt collector cannot falsely claim to be an attorney if they are not. A debt collector cannot falsely claim that you will be arrested if you do not pay. A debt collector cannot misrepresent the amount you owe. A debt collector cannot falsely claim that legal action has been taken or is imminent if it has not been. A debt collector cannot falsely imply they work for a government agency. A debt collector cannot tell you that failing to pay will result in the seizure of your property if that is not legally accurate for your specific situation. Every one of these false representations is a separate federal law violation. In a single phone call, a debt collector who tells you that an attorney is reviewing your file, that a lawsuit has been filed, and that your wages will be garnished immediately if you do not pay today, may have committed 3 separate FDCPA violations in under 2 minutes. Violation number 5. Contacting third parties about your debt. With very limited exceptions, a debt collector is prohibited from discussing your debt with anyone other than you, your spouse, and your attorney. They cannot call your parents and tell them about your debt. They cannot call your employer and discuss the nature of the call. They cannot contact your neighbors, your siblings, or any other third party and reveal that they are calling about a debt you owe. If a debt collector has contacted someone in your life about your debt, that contact is almost certainly a federal violation, and depending on the circumstances, it may also give rise to claims beyond the FDCPA under state consumer protection laws. Violation number 6. Continuing to contact you after a written cease communication request. Under the FDCPA, you have the absolute right to send a debt collector a written request to stop contacting you. Once they receive this letter, they may only contact you one more time to confirm they are ceasing collection activity or to notify you of specific legal action they intend to take. Any contact beyond that single communication is a federal violation. This is one of the most powerful tools available to you under the FDCPA and one of the least used. A simple, certified letter sent to the debt collection agency stating that you request they cease all communication with you immediately is legally sufficient to trigger this protection. Violation number 7. Failing to provide debt validation information. Within 5 days of first contacting you, a debt collector is required by law to send you a written notice containing the amount of the debt, the name of the creditor to whom the debt is owed, and a statement of your right to dispute the debt within 30 days. Failing to provide this notice is an FDCPA violation. If you request validation of the debt in writing within 30 days of receiving this notice, the debt collector must stop all collection activity until they provide you with verification of the debt. If they continue collecting without validating the debt after you request verification, every collection contact during that period is a separate violation. This debt validation process is critically important because a significant percentage of debts in collection contain errors. Debts may be past the statute of limitations. Debts may have already been paid. Debts may have been sold between collection agencies, and the current collector may have no documentation to validate what they are claiming you owe. Requesting validation forces the collector to prove the debt is real, accurate, and legally collectible before you pay a single dollar. Now, let me give you the complete action plan for the moment a debt collector calls. Step 1. Do not panic and do not volunteer information. The moment you answer a debt collector call, your instinct may be to explain your situation, apologize for the debt, or promise to pay as soon as possible. Do not do any of these things. Everything you say on that call is documented and can be used in collection efforts. You are not required to explain your financial situation. You are not required to make any promises. You are not required to do anything other than listen. Step 2. Ask these 3 specific questions immediately. What is your name? What is the name of your company? What is the name of the original creditor and the amount you claim I owe? Write down every answer you receive, the date and time of the call, the name of the person you spoke with, the company they claim to represent, the original creditor name, the amount claimed. These details are essential for every step that follows. Step 3. Say these exact words. I do not acknowledge this debt. Please send me written verification of this debt at my address. I will not discuss this debt further until I receive written verification. Then end the call. You have done everything you need to do on that first call. You have not acknowledged the debt, you have not made any promises, and you have formally triggered the debt validation process that legally requires them to prove the debt before a continuing collection activity. Step 4. Send a debt validation letter by certified mail with return receipt. Within 30 days of their first contact with you, send a certified letter to the collection agency requesting written verification of the debt. The letter should state clearly that you dispute the debt and request that they provide the name and address of the original creditor, the amount of the debt and how it was calculated, and proof that the collection agency has the legal right to collect this debt. Certified mail with return receipt creates a legal record of when your request was received. From the moment they receive it, they must cease collection activity until they provide full validation. Step 5. Check the statute of limitations for this debt in your state. Every type of debt has a statute of limitations, a legal deadline after which the debt can no longer be collected through a lawsuit. In many states, the statute of limitations on credit card debt and medical debt is between 3 and 6 years. Once a debt is past the statute of limitations, it is called a time-barred debt. And while collectors can still ask you to pay voluntarily, they cannot sue you to force collection. This is critically important because if you make a payment on a time-barred debt, or even acknowledge the debt in some states, you can restart the statute of limitations clock and expose yourself to legal action you were previously protected from. Never make any payment or acknowledge any old debt without first confirming where it stands relative to the statute of limitations in your state. Step 6. Document every potential violation you observe. Keep a written log of every contact from the debt collector. The date, the time, who called, what was said, and any behavior that appeared to violate the rules I described. If they call outside permitted hours, document it. If they use threatening or abusive language, document it. If they contact a third party about your debt, document it. If they continue contacting you after a cease communication letter, document it. This documentation is the foundation of any FDCPA claim you choose to pursue. Step 7. Contact an FDCPA attorney if you have documented violations. FDCPA attorneys work on contingency for these cases, meaning they receive no payment from you unless they win or settle. You can find FDCPA attorneys through your state bar association, through the National Association of Consumer Advocates at naca.net, or through a basic web search for FDCPA attorney in your state. The initial consultation is typically free, and the attorney will assess whether your documented violations give rise to a viable claim. Let me tell you about Marcus. Marcus is 47 years old and lives in Texas. He fell behind on a credit card during a period of unemployment, and the debt was eventually sold to a third-party collection agency. Marcus was embarrassed about the debt and dreaded the collection calls. When the agency started calling, he would sometimes not answer, and sometimes pick up and apologize and promise to pay when he could. Then, one evening, the agency called at 9:45 at night. Marcus happened to look at the clock when his phone rang. He wrote down the time. The next morning, he searched online for debt collector calling hours and discovered the FDCPA for the first time. He started keeping a log. Over the following 3 weeks, he documented 2 more calls after 9 p.m., a call to his sister, during which the collector mentioned his debt, and a call during which the representative told him a lawsuit had already been filed against him, which was false. Marcus contacted an FDCPA attorney. The attorney reviewed his documentation and identified 4 separate violations. The case settled within 60 days. Marcus received $1,400 in statutory damages, and his attorney fees were paid by the collection agency. The settlement agreement also included removal of the collection account from his credit report. Marcus did not pay $1 to resolve this situation. He was paid. Marcus did not have a complicated case. He had documentation, and he had found someone to explain the rules. Everything Marcus did to reach that outcome, you can now do too. Before I close, let me bust 3 myths about debt collection that are keeping millions of Americans from claiming their rights. Myth 1. If I ignore the debt, it will go away. Ignoring a debt does not make it go away. It can result in a lawsuit, a judgment, and wage garnishment. The right response to a debt collection call is not to ignore it. It is to engage strategically, using the tools the FDCPA gives you. Myth 2. I owe the debt, so I have no rights. False. The FDCPA protects you regardless of whether you owe the debt. Your rights under the FDCPA are not conditioned on the debt being invalid or disputed. A collector can be violating federal law while pursuing a completely legitimate debt. The violation is about how they collect, not about whether the underlying debt exists. Myth 3. Suing a debt collector is expensive and complicated. False. FDCPA cases are specifically designed to be accessible to ordinary consumers. Attorneys take these cases on contingency. Filing fees are minimal. Many cases settle quickly once a lawyer sends a demand letter. The system was built specifically to make it financially viable for regular people to enforce their own rights. Let me bring everything together. When a debt collector calls you, the power in that conversation is not theirs, it is yours. The FDCPA gives you the right to demand debt validation, the right to stop all contact with a single letter, the right to sue for up to $1,000 per violation with your attorney fees paid by the collector, the right to challenge the accuracy and the legal validity of every debt they claim you owe. You do not have to panic. You do not have to explain yourself. You do not have to promise anything. You have to ask 3 questions, write down the answers, and say the words I gave you. The debt collector on the other end of that call does not want you to know any of this. Their business model depends entirely on you not knowing it. Now you do. If this video helped you, hit the like button right now and share it with someone in your life who is dealing with debt collection calls. That share could put money in their pocket and end harassment they have been living with for months. Subscribe to Alert Americans because every week we bring you exactly this, the information that protects your money, your rights, and your future before you need it. Stay protected. I will see you in the next one.